Hello everyone, welcome back to another episode of Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. In an important update, the Supreme Court has today initiated a suo moto case to ascertain the safety compliances of coaching centers in Delhi. This was done in the wake of the recent tragedy where 3 aspirants died in a flooded basement at Rao's IAS coaching center in Delhi's Old Rajendra Nagar. The bench of Justices Suryakant and Ujjwal Bhuya was hearing a petition filed by the petitioner Coaching Center Federation against an order of the Delhi High Court passed in December last year, where it issued a slew of measures to regulate the exercise of inspection of all the coaching centers. Even though it dismissed the petition with the cost of 1 lakh rupees, the court decided to take suo moto cognizance of the larger issue. So it issued notice to the Union Ministry of Urban Affairs as well as the Delhi government, asking them to demonstrate the safety norms prescribed and the effective mechanism introduced so far for its compliance. In the next update, the Delhi High Court today dismissed the petition filed by Chief Minister Arvind Kejriwal challenging his arrest by CBI in the corruption case in relation to the liquor policy scam. Kejriwal had contended that his arrest in the CBI case was an insurance arrest as an afterthought to the interim bail granted by the Supreme Court in relation to the ED case. He also said that the policy was not only signed by him but also the then LG Anil Baijal, and from that logic, the former LG and the bureaucrats involved in the process should also be made an accused. On the other hand, CBI had said that Kejriwal was the sutradhar of the entire scam and that there was direct evidence to show his involvement. It was said that trial court had already given a finding that the arrest was not illegal and thus the probe agency had passed the stage of legality of arrest in the court below. Justice Neena Bansal Krishna has disposed of Kejriwal's bail plea now with the liberty to approach the trial court for the relief. The court held that it cannot be said that the arrest was without any justifiable reason or is illegal. Recently, if you remember, the Supreme Court had granted interim bail to Kejriwal in the money laundering case while referring his petition challenging the arrest by ED to a larger bench. In a significant development, the Supreme Court has today held that the Lieutenant Governor of Delhi has the power to nominate aldermen to the Municipal Corporation of Delhi without the aid and advice of the Delhi government. A bench comprising CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala delivered the judgment in a petition filed by the Delhi government seeking quashing of notifications through which the LG of Delhi appointed 10 nominated members to the MCD on his own initiative without the aid and advice of the Council of Ministers. The court decided that the power given to the LG flows from the Delhi Municipal Corporation Act. Therefore, the LG did not have to follow the aid and advice of the Delhi government. Since this power was specifically given to the LG by law and not a general power of the government, the LG had to follow the statutory mandate instead of taking advice from the Delhi government. The Supreme Court today issued a notice in a petition filed by the state of West Bengal against Calcutta High Court's judgment, which quashed classification of 77 communities as other backward classes given under the West Bengal Backward Classes Other Than Scheduled Castes and Scheduled Tribes Reservation of Vacancies in Services and Posts Act of 2012 and cancelling all OBC certificates issued in West Bengal after 2010. At the commencement of the hearing, Senior Advocate Indra Jaisingh, appearing for the state, submitted that the executive function of the state had been taken away with the High Court order. She argued about the consequences of striking down the list of reservations. She said that this in turn affects NEET as well because there is a reservation for education also. Countering this argument, Senior Advocate Mukul Rohtagi said that the court should not pursue the case, saying that this is an egregious case. He also submitted that there was no survey done, and to support the same, he referred to the High Court's judgment. The bench of CJI D.Y. Chandrachud, comprising Justices J.B. Pardiwala and Manoj Mishra, also issued notice on the stay application of the impugned order today. The bench asked the state to file an affidavit explaining the process followed for the classification of 77 communities as OBCs, the nature of the survey, whether there was a lack of consultation with the Backward Classes Commission in respect of any communities in the list of 77 communities designated as OBCs. Apart from this, the court also asked whether any consultation was done by the state for the subclassification of the OBCs and clarified the nature of the study relied upon. The Supreme Court has today extended the interim order of status quo over Uttar Pradesh and Uttarakhand government's directives that eateries along the Kanwar pilgrim route must display names of the owners and staff. A bench of Justices Rishikesh Roy and R. Madhavan was hearing the petitions filed by Association for Protection of Civil Rights, TMC MP Mahua Moitra, Professor Apurvanand and columnist Akar Patel against the directives of UP and Uttarakhand governments. On the last date of the hearing, if you remember, the matter was adjourned as State of Uttar Pradesh had filed a counter affidavit, but the same had not come on record. Despite objections by state authorities, the interim order passed by the court earlier, staying the directives, was extended. Today, the matter could not be heard, but the bench, without passing any specific order in individual cases which remained to be heard, directed that the matter be relisted. And now let me tell you that the Apex Court has today granted 6 months extension of Justice Gita Mittal committee, which is seeing several humanitarian aspects of the ethnic violence in Manipur. The Justice Gita Mittal committee was constituted by the top court in August last year to address the humanitarian concerns stemming from the ethnic clashes in Manipur. The development came subsequent to the court slamming the Manipur police investigation as tardy and expressing anguish at the sexual violence committed against women amidst the sectarian conflict. A petition has been filed in the Supreme Court seeking constitution of a high-powered committee chaired by a retired Supreme Court judge to inquire into the allegations of manipulations of the EVM during the recent Lok Sabha elections. The petition has sought a probe into the alleged derelictions by the Election Commission of India. If you recall, a few months back, the Supreme Court had rejected the pleas seeking 100% cross-verification of EVM's data with VVPAT records. The court had rejected the prayer after referring to the protocol in place, technical aspects, as well as the data which was on record. It was also observed that the suspicions regarding EVM tampering were unfounded and reverting back to the ballot paper system would undo the reforms that have taken place over the years. In the present petition, the petitioner has argued that ECI has acted arbitrarily without adopting the required safeguards. The petition, among others, has referred to certain records, including videography, photographs, letters, documents, etc. It adds that if the same is continued, then it will adversely impact future elections in India. The petition was listed before a bench of Justices Surya Kant and Ujjal Bhuya today. The bench was of the view that the matter should be heard by a bench led by Justice Sanjeev Khanna, who passed the judgment relating to the EVM VVPAT verification. Accordingly, the matter was adjourned, directing it to be listed before a bench led by Justice Khanna, subject to the orders of the CJI. In another update, the Delhi High Court today directed Delhi government's Social Welfare Secretary to personally visit tomorrow Asha Kiran shelter home where 14 inmates have died last month, including a child. A division bench comprising Acting Chief Justice Manmohan and Justice Tushar Rao Gadela was hearing a PIL seeking a court-monitored probe into the deaths. It seeks a CBI inquiry in the matter as well as social audit of all shelter homes in the national capital to ensure that the correct picture and living conditions there are brought to light. The counsel for the petitioner submitted that there are severe lapses in the functioning of the shelter home, including Delhi government-owned bodies. The Delhi government's counsel told the court that out of 14 inmates who died, only one was a child and others were adults. He informed the court that all the deceased persons were suffering from severe category of intellectual disabilities and other comorbidities. The court said that 14 deaths in 1 month in a shelter home could not be a coincidence. Noting that the deceased persons were suffering from tuberculosis, the court directed the state Jal Board to test the quality and condition of water in the shelter home forthwith. The court sought report from the Delhi Jal Board as well as the secretary on the visit and has listed the matter for hearing on 7th August. Stay tuned. And lastly, the Supreme Court has today granted the Enforcement Directorate additional time to address its plea against New Delhi Television, that is NDTV. NDTV, let me tell you, is being investigated by ED for allegedly violating the Foreign Exchange Management Act. They tried to resolve the issue by applying to the RBI for a settlement or compounding, but their applications were returned. NDTV then filed a legal challenge against the RBI and ED's actions. The Bombay High Court in 2018 decided that the settlement process with the RBI should continue and be handled strictly according to the law. Against this order, ED has now approached the Supreme Court, and the bench of Justices Abhay S. Oak and Augustine George Massey heard the matter today. After the advocate appearing for ED sought time and requested for the matter to be listed next week, Justice Oak remarked that there may be a shift in ED's stand due to changed circumstances. With this, the matter was scheduled to 12th August, marking it as the last chance for Enforcement Directorate. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.